Hello everyone, and welcome back to another Patexia IP Matters webinar. My name is Pedram Sameni, founder and CEO of Patexia, which is a IP platform for IP professionals such as patent attorneys and IP experts. And as you know, we use them for different kinds of patent studies through direct consultation and crowdsourcing, for example, validity, and even more complex services such as IP insurance. So today it's my pleasure to introduce Mr. Manny Schecter, Chief Patent Counsel of IBM, who is joining us from New York. Mr. Schecter is the Associate General Counsel and manages the IP attorney at IBM. He's been there his entire career for over 20 years. And during his time, he helped IBM generate over $20 billion in income from IP, and also maintaining its position for almost 22 consecutive years, as the top filer in the U.S. Manny is active in intellectual property policy matters, including legislative, judicial, and patent office reform, and he specializes in the application of technology to improving patent quality. So, without further ado, I would like to pass it to Manny, and today he's going to talk about Alice case and in particular aftermath of this Supreme Court case. Thank you. Manny, please.
Okay, thanks, Pedram. Am I coming through okay?
Yeah.
Okay. Hello, everyone. It's great to talk to you today, even if I can't see you. We're going to talk a little bit about what's going on with the Alice case. I'm sure I won't be able to answer all of your questions because, well, no one can, but I'll do my best to take you through some highlights as I currently see them. Pedram, if you'd advance to the next slide, this is the agenda for today. I'm not going to spend a lot of time in the first couple of bullet points here because our time is limited. So I will run through a couple of things quickly, but not too much. That's okay, Pedram. You can go to the next slide. We'll just keep right on going. So this particular slide, slide 4, is the way the world, the way much of the patent community saw the Alice decision and the cases, the Supreme Court cases leading up to the Alice decision. We don't need to go into any individual person's comments here, but the point is, the reaction has been very sharp. People see Alice as a very significant change to the patent system in the United States, and I'm sure most of you that are dialed in do as well. Why don't we go forward, Pedram? I show you this next slide simply to tell you that in earnest, IBM and me included filed an amicus brief in this case. We're not going to discuss the amicus brief now. I'd rather use the time on some other more substantive matters, but I felt in complete honesty I should tell you that and give you the opportunity to look at that brief on your own. Pedram, if you'd advance 2 slides, that'd be great, to the flowchart. There should be one more slide. There you go. So this particular slide, I see very few presentations relating to patentable subject matter or the Alice decision these days without someone actually showing this flowchart or something very similar to it. This is, of course, the test for patentable subject matter these days, as depicted by the USPTO. Without, spending a lot of time on it, hopefully you all remember now that the Step 1, Step 2A, and Step 2B, where Step 1 is whether the claim is drawn to one of the 4 classes of claims. Step 2A is whether the claim is drawn to one of the judicial exceptions, laws of nature, natural or physical phenomena, or an abstract idea. And Step 2B, if Step 2A is in fact yes, whether the claim also recites something, quote, significantly more than the judicial exception. So why don't we move forward another slide. Um, I want to just quickly get to the crux of the problem that we're all now left with. I think it's pretty straightforward. The Supreme Court, I think, was trying not to disrupt the patent system very much. I think there's no doubt that they were concerned, that they'd been hearing that patents were issuing or patents were being asserted for inventions that some people thought didn't merit patenting, and the Supreme Court was trying to help in that regard. They also realized that whatever they did, they didn't want to make too big of an adjustment, as they say in the bottom bullet here, lest it swallow all of patent law. So I really believe they were trying to make a small adjustment. That's not actually what I think ended up happening, and I think the crux of the problem goes back to a few other things. Remember, they also said essentially all claims have abstract ideas, and as you see on this slide, we don't need to tell you what an abstract idea is. We're not going to tell you how to delimit an abstract idea. So Pedram, if you go to the next slide, there you have the crux of the problem. If all inventions rely on an abstract idea, courts told us that. If that's true, and the court hasn't told us how to delimit what an abstract idea is, and we don't know otherwise how to delimit an abstract idea, how can we then determine whether an invention, as claimed, is significantly more than that abstract idea? How can we know whether something is more than something we don't know what that is? It's a conundrum. We're all stuck with that conundrum right now. And of course, it's creating a lot of uncertainty in the patent system. Pedram, why don't you advance the slide? So for the next few slides, we'll go very quickly. There's some quotes in the case about, or lack of quotes in the case that indicate there was no sweeping statement that software is not patent eligible or business methods are not patent eligible. They recognize that computers play an important role, and that a computer-implemented invention can, in fact, be subject matter eligible. But, advance the slide, please, merely tacking a computer on to an otherwise ineligible claim isn't going to then make it eligible. That's basically what the Supreme Court said. Why don't we advance the slides again? And so, we're left now wondering what exactly is an abstract idea and what makes something significantly more. I've listed for you what came out of the case, or what we've seen come out of the USPTO or some subsequent cases. We don't need to go through these four exceptions. These four examples of abstract ideas from the case. Although I would point out it's rather odd that they talk about fundamental economic practices long prevalent, because that to me suggests that a practice which starts out as being that a practice can start out being patentable subject matter, but after it becomes long prevalent, it can become non-eligible subject matter. And I don't know how you know when you cross that path. Similarly, in the next bullet, they didn't say all methods of organizing human activities are abstract. They said certain methods of organizing human activities are abstract, and so on. So even in the examples, we have uncertainty. How unfortunate. Advance to the next slide. Here's similar kind of description of what we've seen on significantly more than the abstract idea. I won't dwell on that. Pedram, let's move forward. That gets us to what's now happened since the cases. And in these next slides, I'll talk about what's happened with the subsequent case law, and then some more things. You're perfect, right on slide 17. Thank you. This slide, tells you a lot all by itself. We had a relatively low rate of district court findings of invalidity for ineligible subject matter, and we've seen, the number of findings skyrocketing. some people would say that in itself is troubling. I'll leave that for you to decide, but it certainly shows that the case has had a tremendous impact. Why don't we move to another slide? And you can see that in the invalidity rates on 101 grounds that have occurred subsequently, either in the district courts or in the federal circuit. The invalidity rates are very high. By the way, these rates came from Bob Sachs's Bilski blog, and they're now some months old. So if the percentages are slightly different now, that's why. But the gist is still basically the same. Why don't we move to the next slide? So some people are out there saying, gee, this is really nothing to get excited about because most computer implemented inventions that include technical content are upheld. They're up, as you can see here, this particular person was saying they're upheld in 2/3 of district court decisions. That's great. My concern is, what about the other third? Why is it that technical inventions, what most of us think are normally patent eligible subject matter, why is it that 1/3 of them are being found invalid? That to me is still quite troubling. Flip the slide. So just to give you some idea of what this is like, I've given you, depictions as best I can from 3 cases in the last year or so that courts have ruled on. I know this doesn't really tell you exactly what's claimed, but I'll show you that in a second. Think about whether you think any of these are patent eligible subject matter. Pedram, hit the button, and there you go. None of them were found to be patentable subject matter, and I think most of us would agree that the general subjects of these cases and of these claims was such that there's ample technical content. So we're still struggling to find exactly what is eligible and what's not. Pedram, flip to the next slide. I don't want to go into this the Thales case in detail, but if you just look at that final sentence underlined in red, you'll get an understanding of some of what's happening here. In this particular claim, you had objects and sensors, physical elements that were being manipulated, but the Court of Federal Claims says it was ineligible, and it appears it would not have been ineligible if they had simply mentioned, instead of objects, a fighter jet and a pilot's helmet, which were one of the disclosed embodiments. Of course, the problem that I have with that is, so I think all of us could envision that something similar could be implemented on, I don't know, in a tank and a tank commander's helmet, or a race car and a race car driver's helmet, and so on and so forth. And what the court here at least seems to be saying is, you got to claim each one of those items. You got to specify each one of those types of items, or it's not ineligible. And intuitively, that doesn't make sense to me, and I think it's counter to the way we were all taught to write claims. So, of course, that too has created a lot of uncertainty. So if you go to the next slide, that's fine. What are we left with? Well, we have a lot of conflation of issues, Section 101 being conflated with the other statutory grounds. There's talk about preemption. What does it mean? How much preemption is there? We see courts parsing up claims rather than looking at them as a whole. Forever using hindsight. Bottom line is, not a lot of consistency in the system at all as a result of the case. Why don't we go forward? So what has subsequently happened in the USPTO? Well, you have similar results going on at the PTAB, and you have some people who think the fact that PTAB has been invalidating a lot of claims is a good thing, or shows justifies the case. Others that think just the opposite. For the moment, I'm not going to dwell on that. If we have time, we can certainly come back to that later. Let's move to the next slide. This is data that I actually also got from Bob Sachs, and I reformatted it to make it a little more helpful here. If you notice, quickly I should point out that the horizontal axis is not in equal time increments, but it shows you a number of data points both before and after the Alice decision. And the sort of traditional blue color it shows the number of rejections, or the percentage of rejections based on Section 101 in Tech Center 2100, and the greenish blue color is the same thing but for Tech Center 3600. And what you can see, of course, is that in Tech Center 2100 computer architecture area, if anything, the rate of 101 rejections has actually gone down, or maybe been constant throughout. But the rate of 101 rejections in Tech Center 3600, went up quite a lot. And the data that I'm showing you here actually understates that effect, because if you zero in on Class 705 and business methods rather than just Tech Center 3600 as a whole, what you would find is a still significantly higher spike. So it's quite obvious that the Patent Office, whether intentional or not, has been focusing its attention on business methods. Pedram, why don't you move forward, please? So, lots of people then had hoped that the USPTO's subject matter eligibility guidelines, which we now have a few iterations of, would bring some clarity to the matter. I think the USPTO laid out some things that are certainly helpful, reminding examiners to focus on the claim as a whole and articulate a prima facie case and all of that kind of good stuff. All good things, but still, in my mind, not enough. And I'm not suggesting that that's the fault of the USPTO. They're simply struggling to understand and apply the case just as the rest of us are. So, Pedram, if you'd go forward, I gave you my take on the guidelines, and I'll make one point with the very next slide if we move forward. The guidelines tend to try to use examples, since we have no other guidance, to try to demonstrate what it means to be abstract or not. And of course, the problem with that is we only have a very limited number of examples, and if we went by the letter of the example, we could never technically find anything else to be abstract, because unless it was exactly like one of the examples. What we really need is to be able to extrapolate between those examples so we can understand where the boundary conditions actually lie. And what I'm really showing you in the slide here is that to me, that's kind of like trying to complete a paint-by-number painting as you see it completed on the right, but starting with only a few of the color blocks filled in, like you see in the image all the way on the left. So ask yourself, if that's all that you were given, if those examples of abstract ideas are essentially what you have as the color blocks in that left picture, whether you could actually then complete the picture on the right from that. I submit that the answer is no, you can't, and that frankly we're a very long way from being able to get there, and I hope that we don't have to go through a whole nother set of cycles of these patentable subject matter eligibility cases in order to ever get an answer, because I think that means it won't happen in my lifetime. So why don't you move to the next slide? We have lots of lingering issues. As I just mentioned, the examiners are struggling with this just like we are. Lots of people are complaining about the need for more examples, the fact that some of the rejections lack specificity. We get somewhat conclusory statements. We've done some surveying of this. The education that's been provided the examiners, I think, has helped things, but we still have a ways to go. Again, no blame on anyone there. Everybody's doing the best they can. Pedram, why don't you move forward 2 slides? It still leaves me where I think we were before, which is before Alice came out, I didn't understand the law of subject matter eligibility. I've heard professors say that subject matter eligibility is the bane of their existence because it's so hard for them to teach. And frankly, I don't think anything has changed. We still have this knotted nest of subject matter eligibility cases that I don't find to be consistent throughout their use, and I think it's really time for us to think differently and make some wholesale changes. Now, aside from the consistency problem, that is, whether the courts are consistently holding what is eligible and what is not eligible, and whether the examiners are doing that and whether the PTAB is doing that, there's another problem. Go to the next slide. And that problem is, do they all agree with each other? Right? The examiners, as I just showed you, seem to be focusing on finding business methods ineligible. That doesn't necessarily mean, for example, that at the end of the day, that's what the courts, that's how the courts are going to interpret what is and is not ineligible. So if we go to the next slide, my very first bullet point here is the USPTO's interpretation doesn't have the force of law. Just because cases are issuing now as eligible, most likely not business methods, doesn't mean 5 or 10 or 15 years ago, when those patents get enforced and or litigated, that the court isn't going to think differently. So have we really resolved matters here? I still think the answer is not. Tremendous amount of uncertainty still resides in the system. And whether or not you like what the court was trying to do or not trying to do, that uncertainty is still, to me, quite troubling. So if we'll move forward 2 slides, we get to the final point on the agenda, which is, what happens going forward. So go another slide. I've given you some claiming tips here. If you're thinking that I was going to make it possible for you to submit claims and get them to zoom through the patent office, I apologize for that, but I just don't think anyone has the answer to that. Many of the things you see on this page you've seen in other presentations on this subject, avoiding economic claim language, inserting more technical content. So those are all good things to do, but at the end of the day, they're not magic. Go to the next slide, Pedram. I also gave you some ideas for prosecution, trying to get early understanding of where the examiner's thinking is, delaying prosecution without causing prosecution latches, of course, perhaps in order to, until we get to a more stable understanding of the law, although I think that time will be considerable. A challenging examiner notice or a lack of prima facie case, that kind of a thing. All good things, but let's keep moving forward. Now you have to ask yourself, well, if you're in litigation, what does this mean to you? Well, if you're a defendant, of course, the Alice case may add to your defense. I think it's becoming quite common for defendants in cases to raise the judicial exceptions as a defense to patent infringement. As a plaintiff, of course, it means you have to vet your patents before assertion. You need to do things like looking at the 101 success or invalidity rates in whichever jurisdiction you happen to be in, and be prepared for the arguments that might come your way. That, of course, is no easy task, but it certainly is something that can be done and you need to be prepared for. The real conundrum, I think, comes in, for a lot of us, we have cases where we're a plaintiff and we have other cases where we're a defendant, and we don't want to make arguments, albeit about different claims, about different patents, but we don't want to make arguments in one case that might undercut our thinking in another case. That's a hard temptation to resist when you're on both sides of the fence. Nevertheless, I encourage everybody to think that way, because it's all too easy to take the best argument or the easiest argument to make in the short run, only to find out later when you get to the next case and you're on the other side that, gee, I wish I hadn't argued it quite that way. Why don't we go to the next slide? The real question that I think is on everyone's mind is, if for those of us that are not happy with the case, what do we do about it? We continue to search for clarity. I don't see clarity coming anytime soon. Some people say, gee, there are other forms of intellectual property that are available, copyright, trade secret. They're great. We should use them. Of course, everyone on this call knows all the different forms of intellectual property serve different purposes. So, I would say relying on them is not a cure to the issue. You know, the U.S. I've seen people saying, "Oh, the USPTO should just ignore the Alice case." Well, you know, it can't. It's binding upon them. So people then say, "Well, maybe another case is coming down the pike." You know, there are some cases that have been working their way through the system. I think that's great. I think a lot of people would like to see a case in which the Supreme Court actually finds a claim to be patent eligible subject matter. That would be great. I have to say, from my perspective, one, I'm not so confident that the Supreme Court will accept a case like that. I think in their minds, they've now taken a few cases in recent years on patent eligible subject matter and probably don't want to tackle it yet again. So I'm not confident we'd get that. But even if we did, even if a case gets to the Supreme Court, query where that's really going to get us. It might get us a set of claims that the court has found to be patent eligible, that it's going to delimit exactly what is abstract and what's not, and what's significantly more and what's not. It's going to be focused on those claims. So since the court didn't define those things before, I'm not confident that if we get another case, we're going to get that the next time. So that takes us to legislation. Might we get legislation? We can go to the next slide. Thank you. Some people say it's better to do nothing because, you know, they fear that that we could get Congress codifying our worst fears. I suppose that's possible. My own view is, you know, right now we have a lot of inconsistency in the system, and I think we ought to take a shot at trying to do something about it. It doesn't necessarily mean we have to greatly alter exactly what we all think is patentable and what's not, but clarity, I think, is always helpful, and generally we can all agree on that. Of course, if we try to legislate away the judicial exceptions, you know, it's never fully assured that they're gone. The courts can point back to the Constitution and read things in that, after all, what we're coping with already is a judicial exception that's nowhere in the statute. So, you know, there's always uncertainties along those lines. The real issue here is we need community consensus. There are plenty of folks the last year that have been talking about the possibility of legislation on an individual level, on a company level, on an association level, but we've yet to see consensus form. And I think one of the things we really need is people to be more vocal about the need for that consensus. Congress is, of course, not even paying any attention to this because no one is complaining about it, at least no one that Congress tends to listen to. Business executives aren't going into Congress and saying something is wrong and we need to fix it. So if you are on the side of someone who thinks the case is great, well, that's fine. If you're on the side that thinks there's way too much uncertainty now and we need to do something about it, and Congress is the only route, then I suggest you send some of your senior officials from your companies in to see your local congressman to get them to start getting them to be excited. Now, of course, we're in an election year. We still have patent reform pending. We have other legislation in the IP area pending, the trade secret bill, for example. So obviously there's priorities and timing issues, and I'm not suggesting that isn't a complicated beast. All of that has to be navigated. But if we go to the next slide, I would say there are some things we can certainly say about any potential legislation here, which is it needs to be technology neutral. We need to build in some of the principles here that seem to be going awry. That is, patentable subject matter issues shouldn't be wandering into the fields of 102, 103, and 112. The claims need to be considered as a whole and not parsed, and so forth. So with that, I'm going to step back. I think we're right at the end of the half hour. I know there may be some questions, and Pedram may have some. I see he's put up one final slide, which is, hey, look, the message here is clearly, hey, look, the software industry, the computer industry as a whole is a very important industry worth billions of dollars, and it's imperative on all of us to help Congress, the courts, whoever, get it right and make sure that the industry continues to thrive. So with that, Pedram, you can go to the last slide, and I'll be happy to take questions.
Thank you so much, Manny. Great presentation. There are a couple of questions, and if anybody has any question, you can use the page, Patexia page, to ask your question. You can ask it anonymously as well. So I think you answered one of the questions. The question is, do you see another Supreme Court case that potentially can change the path for software patents? Anything on top of what you mentioned, I guess?
No, I mean, I'm really not optimistic that that a case is going to get taken by the Supreme Court, though I wouldn't mind it if it did. But even if it does, I'm not optimistic that at the end of the day it gets us very far.
Okay. The other question is, obviously with this Alice case, IBM as #1 filer, people are curious to know if that has impacted your overall filing strategy, or how do you see that going forward?
Well, to be honest with you, it has not impacted our filing strategy a great deal. For one thing, 10 years ago, we made some changes to the way we consider technical content in our invention disclosures and whether we file patent applications upon them, and we announced that publicly. You can go back and find some of that out on the web, I'm sure. But the point is, we pulled back a bit. We raised the level of technicity in our cases some. That doesn't mean we did a perfect job of that, but the point is, we thought there was a backlash coming in this general area, and we tried to anticipate it some. So that means that when the cases actually came, though they're not necessarily exactly what we were expecting, we had already taken some actions for that. Second thing I would say, with respect to IBM, of course, is while we certainly file a lot of cases that are in the general area that they could be impacted by what's going on here, the fact of the matter is it's still a very modest amount of our patent portfolio. So from a strategy perspective, it's maybe not as significant to me as it is to some other filers. On a more micro level, we didn't instruct our teams to go out and avoid certain technical areas or cut off their business method applications. Certainly we've given them education, just like the education I provided here. Certainly we've done the same things that most of the rest of the people who are listening online have done, but we've after the education largely left that to our individual practitioners to judge what's right in view of the individual invention that they have before them to consider filing a patent application on. I hope that answers your question.
Yeah, great. Yeah, with that, we're almost we've passed our 30-minute time, and I would like to thank you, Manny. Our next webinar is going to be on March 24th. It's about posturing IPRs for early settlement, and Tim Bianchi from Schwegman Lundberg is going to talk about that. I would like to thank everybody who joined today. The presentation and slides are going to be available. We will email you a link to the materials later on. Thank you very much, and thank you, Manny, for joining us today.
Sure, happy to help. So long.
Bye.